No, they have the authority for intensive revision. The problem is with the manner in which they are doing it. Rahul Gandhi showed that
there were duplicate entries in the Haryana Assembly votes.
Yes. Now this could have easily been avoided.
How important do you think at this point of time is for the Election Commission to actually come up with a uniform protocol?
So they want to just have an arbitrary power without any transparency, without any guidelines to decide.
I know that a challenge is already pending. What do you think is the solution? Hello and welcome to In Focus. I'm Aratrika Bhaumik. Last month, the Election Commission of India announced the second phase of the special intensive revision of electoral rolls, which is to take place across 12 states and union territories, including in poll-bound Kerala, Tamil Nadu, West Bengal, among others. The first phase of the SIR exercise, which took place in Bihar, already witnessed intense legal scrutiny. While the poll body has maintained that it has the jurisdiction to conduct such an exercise, petitioners before the Supreme Court have alleged that the exercise in Bihar has led to mass disenfranchisement and also lacks transparency. To discuss the implications of the second phase of the SIR as well as what the Supreme Court's intervention in the Bihar SIR proceedings have yielded so far, we are joined today by Advocate Prashant Bhushan, who is a lawyer practicing in the Supreme Court and also represents the Petitioner Association for Democratic Reforms before the top court. A very warm welcome to you, Mr. Bhushan. Thank you so much for joining us today.
Thank you. My pleasure.
Mr. Bhushan, before we talk about the implications of the onset of the second phase of the SIR, if you could discuss a little about what the status of the Supreme Court proceedings currently is. So, Supreme Court has agreed to hear the Bihar SIR challenge on Tuesday, that is November 11th, and there has also been an application filed by the West Bengal government. However, in the previous hearing pertaining to the Bihar SIR matter, the Supreme Court had refused to record in the order a direction to the Election Commission to publish the details of the voters excluded as well as added in the final electoral roll. Although the Election Commission had orally remarked that it would. So my question to you beginning this discussion is, were details of voters who were added as well as excluded in the final electoral roll compared to the draft electoral roll? Was it done by the Election Commission?
I'm not so sure whether it was done or not done. But throughout this case, throughout this SIR, the Election Commission has been trying to withhold as much information as it can from the people. So initially, they were refusing to even publish who had been excluded from the draft electoral roll and for what reason. Eventually, once the Supreme Court directed them to do so, they did so.
Right.
Thereafter, they have refused to publish the names of the people who have applied for inclusion.
Right.
The names of the people against whom objections have been received. Their own booth-level officers had also written on each application form, recommended, not recommended. They refused to publish that as well. So, what we have been seeing throughout this SIR exercise is that Election Commission is giving as little transparency as possible.
Right.
And with this very, very limited transparency, it's very difficult for anybody to see even these duplicate votes. So one of the issues that has come up is these duplicate votes. So even in this Bihar final electoral roll, there are a lot of duplicate votes. There are also a very large number of votes, crores in fact, where more than 10 or even more than 100 people are residing in the same residence, which have not been properly scrutinized or verified because this Bihar SIR was done in a great hurry. So therefore, the Election Commission is refusing to use the deduplication software. So for example, in this press conference on the Haryana electoral roll, Rahul Gandhi showed that
there were duplicate entries in the Haryana Assembly polls.
Yeah, so the same person in terms of the photo appears sometimes in 100 places, sometimes in 200 places, etc. in one assembly constituency, sometimes in just 2 polling booths.
Right.
There are 200 entries of one person in just 2 polling booths. Now, this could have easily been avoided if the Election Commission had used what is called the deduplication software.
Which it has access to, but is refusing to employ here. And has it used such a software for, let's say, the summary revisions conducted earlier?
Yes, I think they have.
Okay.
I think it is also mentioned in one of their guidelines that they should use it, but they are refusing to use it right now. So with the result that all these anomalies, duplicates, 100 people in one residence, people's father's name being garbled, their own names being garbled and so on, these kind of entries are getting in and without any scrutiny whatsoever. And they are also refusing to conduct what is called a social audit or a Gram Sabha on a booth level, which is actually the most effective way to check who are the people who have died from the previous electoral roll, who are the people who have moved out, who are the bogus people in this electoral roll who do not live there, who are the people who have to be added in the electoral roll, etc. That's the most effective way.
Right. And when it comes to these duplicate voters, this had been flagged before the bench. And the bench had orally remarked that the Election Commission should at least undertake the exercise when it comes to the Bihar electoral rolls. Was it done?
I don't think it was done. I don't think it was done because there are duplicates in the Bihar electoral roll also.
Right.
And there are lots of problems with the Bihar electoral roll also.
Right. Another criticism that has come out of these proceedings is that the polling for the Bihar elections have already begun. And the second phase of the SIR has already been announced. So now when the Supreme Court begins to hear the challenge to the validity of the exercise, the constitutional arguments, does it then become an academic exercise or a fait accompli intervention, so to speak?
No, not yet. But the Election Commission clearly wants to make it a fait accompli, as they have done in Bihar already. I mean, without any proper scrutiny or full scrutiny of the Supreme Court on the SIR process, they did the SIR and they have conducted the election on the basis of this SIR. Now, of course, the examination of the Bihar SIR becomes academic.
Right.
Supreme Court now needs to examine this whole SIR exercise in the rest of the country as to whether it is in consonance with, firstly, with common sense, secondly, with their own, with the Representation of People Act, with the rules, with their own guidelines, with their own manual. So there are many things which are written in their manual, in their own guidelines. So, for example, about citizenship.
Right.
Election Commission has been continuously saying that we are doing this SIR to weed out non-citizens.
Right.
When they were asked how many people were weeded out of Bihar on the ground of citizenship, they didn't
So there is
respond.
no data on how many foreigners were weeded out from the electoral rolls in Bihar.
Informally, the people, the various other organizations and political parties have been saying that not even 100 people were weeded out of the Bihar electoral roll on the ground of non-citizenship.
Right.
Secondly, their own guidelines have repeatedly been saying, for example, in the 2003 SIR and the Assam SIR, they said that, look, it is not the job of the Election Commission to examine citizenship.
Right. And that is something the Supreme Court has also highlighted in its judgment previously, that the jurisdiction of the Election Commission is not to question the citizenship of the electors.
Yes, because how will they do it? So that's the job of either a court or a tribunal or at best the government of India. The Election Commission is not an authority to check citizenship. On what basis will they do? So they gave a list of 11 documents which people should produce.
Right.
Of those 11 documents, only 2 of them are prima facie evidence of citizenship: birth certificate and passport.
Right.
The other documents like school certificate or land certificate or caste certificate, they are also not evidence of citizenship. Election Commission has throughout been maintaining the stand, and that is there in the form for registration of new voters, that you have to give some evidence of residence, some evidence of date of birth, and only a self-declaration on citizenship.
Right.
But they are still saying that we will examine citizenship.
And I think what is important to highlight here, and correct me if I'm wrong, is that this is a de novo exercise. Although the Election Commission has maintained that a similar exercise has been undertaken previously through the summary revisions, where you had electors also give documents proving their citizenship, that is not the case, because this is the stand of the Election Commission before the Supreme Court.
They are saying that this is like the SIR which was done earlier in 2003.
Right, on the basis of which now the electoral rolls are being pruned, on the basis of the 2003 rolls.
Yeah, but they are not following the 2003 SIR, because in 2003, there was firstly no requirement of any voter filling a form, enumeration form. Now they are requiring people to fill an enumeration form, and they are saying that those who don't fill the form will be removed from the draft roll.
Right.
This was not there in 2003.
Right.
There in 2003, the BLO used to go door to door. They used to conduct social audits or Gram Sabha, etc. And from there prepare the electoral roll. There was no requirement of filling up an enumeration form.
Right.
There was no requirement of giving one of these 11 documents. Now, of course, earlier they were not even accepting Aadhaar. Supreme Court said you accept Aadhaar. In the notification, they have said, all right, they will accept Aadhaar as proof of identity, not proof of citizenship. But in the notices that are being sent by BLOs, etc., they are saying that only those other 11 documents minus Aadhaar, they are still not accepted.
So on the ground, that is not the case. Even though formally in the order, it has mentioned that Aadhaar will be the 12 indicative document, on the ground, the BLOs are not accepting. There's a reluctance to accept Aadhaar as one of the identity documents.
Because Aadhaar is the document that most people have. In Bihar, we had examined how many people have which of these 11 documents, and we found that other than the school certificate, which about 40-45% people in Bihar have, no other document was possessed by even 5% of the people of Bihar. That is birth certificate, passport, land certificate, etc., etc.
Right.
So, in fact, about 50% of the population of Bihar didn't have a single one of those 11 documents. They only had Aadhaar. They have ration card, they have Aadhaar, and they have the previous voter's certificate from the voters list. And the Supreme Court has said earlier that the previous voters list, your being there in the previous voters list, will be taken as prima facie proof that you are entitled to be on the voters list. Unless then somebody objects and points out and gives some evidence to show that this person doesn't reside here, or he has died, or he is a fictitious voter, etc., until then your name will not be removed. And therefore, the correct way of doing this is to hold a Gram Sabha, where people will come and they will, all the people of that booth will come, all, or even if 30% come, 30% is enough to point out that this person is not here in this area, this person has died, this person has become 18 after the last election, etc. But they are not doing that.
What the Election Commission has claimed is that Aadhaar is not an authenticated proof is because foreigners also have access to it. That has been the stance of the Election
Yes, but
Commission.
that
So
is
how
their-
true are these claims?
No, that is true that even a foreigner can get an Aadhaar. But a foreigner can get a school certificate also. There is no bar on foreigners studying in schools here and getting a certificate that they have passed class 10 or class 12, etc. Similarly, they can get any of the other
And
documents.
that's the
also.
Aadhaar of a foreigner compared to that of a resident of India. Do they look similar? Is there an expiry date given
No,
when
they
it comes to
look
foreigners?
similar. So a person can get an Aadhaar even if he is a non-citizen. But the thing is that if somebody wishes to challenge somebody's citizenship, then the matter needs to be referred to either the court or a foreigners tribunal or to the government of India.
Right.
And they will examine it after seeing all the evidence. It is not the job of a booth level officer or an electoral officer to examine whether a person is a citizen or non-citizen. And if you examine it on the basis of you have to produce birth certificate or a passport, then vast majority of the people will not be able to prove their citizenship.
Right.
Because they don't have those documents.
Right. Now, all these arguments are, of course, open before the bench currently. What I'm trying to understand is, was there any reasoning given before by the bench as to why it dealt with the procedural irregularities in the SIR, Bihar SIR process, instead of first determining the jurisdiction issue of the Election Commission or the constitutional arguments?
No reason was given. I mean, the arguments in this case have been proceeding in a rather ad hoc manner.
Okay.
1 hour, half an hour, 40 minutes, 1.5 hours, and so on. So there has never been a continuous, complete argument on the validity of the SIR, etc. So they have yet to hear that, and hopefully they will.
The bench has indicated it will hear from the next hearing, the constitutional arguments. Now, of course, we have opposition parties in states who have also challenged the exercise. DMK has moved a petition in the Supreme Court. There was a mentioning made today on behalf of the West Bengal government. How do you foresee these petitions being dealt with by the Supreme Court? Because you also have petitions before the high courts, the individual high courts. Calcutta High Court, for instance, has issued notice on a petition challenging the SIR exercise in West Bengal. So will high courts now individually monitor the SIR exercises in their states, or will the Supreme Court club the petitions together?
I think the Supreme Court will decide most of the major issues, which the high courts will have to follow, because the Supreme Court, the high courts are bound to follow what the Supreme Court has decided. So I feel that the Supreme Court will decide most of the major issues relating to the SIR, and only some issues which remain undecided by the Supreme Court may be decided by the high courts.
Right. Now, for the second phase of the SIR, no document has to be submitted during the enumeration phase. And it has made clear that there will be a claims and objection phase where identity documents can be given to the booth level officers. During the hearings in the Bihar SIR matter, the bench had indicated orally that the Election Commission should come up with a protocol, a uniform protocol or an SOP, so that, these claim forms, these documents, it's not on the basis of the subjective satisfaction of the electoral registration officers. How important do you think at this point of time is for the Election Commission to actually come up with a uniform protocol, as indicated by the Supreme Court before?
No, it's exceedingly important, but many issues are already covered in their own manual and in their own earlier guidelines for the SIR. So they only need to follow those. Unfortunately, they are not. What the Election Commission wants is to get an arbitrary power to decide who should be on the roll, who should not be on the roll, without any transparency. So you cannot even show that, look, there are so many duplicates. They don't even want to give the electoral roll in a machine-readable form, so that independent people can run a deduplication software on that.
Right.
So they want to just have an arbitrary power without any transparency, without any guidelines to decide.
And what you're saying is very important. You're saying there is no need for newer guidelines because these guidelines already exist. Most of them. The Election Commission has consistently in the past given more disclosure of electoral data, as well as when it comes to the identity documents required.
Their own rules say that every objection should be put out on their website on a daily basis, objection to a name. Every application for a new name to be added should also be put out on their website.
Right.
And the electoral roll should be continuously put out on the website, the current electoral roll. Now, they are not even putting out the electoral roll in a machine-readable format.
Right.
They are not putting out the applications for addition of names, or rather objections to names, etc. So then how do people, and then they are saying, why don't you object before the elections? The final electoral roll gets published just one day before the election, because even after the pre-final was published, they are still adding and subtracting names from the electoral.
And this is the data that the petitioners wanted till the last hearing in the Supreme Court.
Yes, we want that continuously. However the electoral roll is being updated, it should be put out on a regular basis so that people can find out, look, here are 100 votes with the same photograph.
Right.
Here are 100 votes with the same name, same father's name, etc. But they don't want people to see that until the last minute they spring some surprise. And after Rahul Gandhi showed what had been done in Haryana, the Election Commission has removed all that from their website also. So they just don't want any kind of transparency. They don't want any guidelines. They don't want to follow their manual, their rules, their own SOP, etc. They just want arbitrary power to decide who should be there, who should not be there, and suddenly on the eve of the election they may add lakhs of voters or tens of lakhs of voters, and you won't even come to know who are the people who have been added until you search manually one by one, as these people have done over the last 6 months, to come out with this evidence that there are 200 votes in the same name, 200 votes with the same photograph, and so on.
Right. So a lot of transparency concerns. And the Supreme Court has not given any direction per se, because these concerns existed even during the Bihar SIR proceedings.
Yes, they did. Unfortunately, the Supreme Court did not.
Okay.
I hope that now they will hear the matter properly and give those directions.
Right. But there has also been certain changes when we look at the order for the second phase of the SIR. For instance, there is a clear notice period which will be given to aggrieved electors, and where they can submit their claims and objections. Documents don't have to be submitted during the enumeration phase. Do you think these are positive developments and these are learnings from the Bihar experience?
Positive, but the problem is that unless the Election Commission puts out the claims on their website, suppose I make a claim or I make some objection, and the Election Commission doesn't put it out on the website, and they ultimately deny that you never made that claim, you never made that objection. There are so many people who are saying that they had filled up the enumeration forms and their names are not on the voters list, that they never received any notice from the Election Commission. So unless there is some way of verifying whether the election, whether such and such a person filled the enumeration form, so they should put out the list of all those people whose enumeration forms have been received. If they are insisting on enumeration forms,
right,
the minimum that they need to do is to put out the list on a daily basis of those people whose enumeration forms have been received, so that people at least have some evidence to show that, look, my enumeration form was received. They didn't send me any notice. The notices should also be put out on their website.
Right. Now, to aid this process, the Supreme Court had asked the State Legal Services Authority to employ a legal aid so that they could help.
That's all notional. There is no such infrastructure of the State Legal Services Authority which can do this.
Which can help with the appeals process.
No, they can't. Impossible.
Okay.
There are lakhs of booths. State Legal Services Authority doesn't have lakhs of people.
Right. Mr. Bhushan, if you could also now address what are the primary arguments of the petitioners when it comes to the statutory authority of the Election Commission?
No, they have the authority for intensive revision. There is no problem with that. The problem is with the manner in which they are doing it. See, there should be no requirement of filling in an enumeration form. Many people in this country, so in Bihar, lots of migrant labor people who are not at home. They can't fill up their enumeration.
But what they have done this time is that any relative can also fill the form on your behalf.
They can, but still there are a lot of people who may still not be able to fill up the form. Their families also may not be able to fill up the form.
There's en masse migration.
Not just migration, temporary migration. They are migrant labor. Their families may also be out. Or they may not even know that they have to fill out the enumeration form. In the Bihar SIR, most of the enumeration forms were ultimately filled up by the BLOs themselves, sitting in their own office.
Right.
Whose enumeration form they fill, whose they don't fill, is up to them. So therefore, that makes it an arbitrary choice on the part of the Election Commission that, well, for these people, the BLO will fill up the enumeration form. For these people, it won't.
Right.
So for example, if directions are issued from the Central Election Commission that, look, don't go to the Muslim neighborhoods, don't go to the Muslim houses, don't get their enumeration forms, let them send the enumeration forms. Even if they send their enumeration form, don't acknowledge them.
The possibility of targeted exclusions here.
Yes. So therefore, unless there is transparency, see, the problem is that we don't trust nobody trusts the Election Commission anymore. It has been functioning as a totally partisan and dishonest body. Therefore, the only way to ensure that they function with some rationality, some system, some transparency is to ensure that everything is recorded. And it is recorded in a manner that it can be seen by people.
And here, for instance, like you mentioned, a lot of migrants will be disproportionately affected. If anybody is unable to fill the enumeration form within the stipulated period, the names will be struck off the rolls, even if their names were there, existing in the rolls beforehand.
Correct.
So that's a violation of the constitutional guarantee of right to vote.
Right. So even the Supreme Court earlier had said that the very fact that they are there on the electoral roll is prima facie evidence that they should be there. Unless you thereafter find out on the basis of some evidence that so-and-so has died, so-and-so has permanently migrated, or so-and-so is a fictitious voter. He just doesn't exist. Until then, his name can't be struck off just because he has not filled up the enumeration form.
Proceeding to the last question of the evening, which is like you mentioned, that there's a lot of lack of trust in the Election Commission as a body. A lot of petitions have been filed. There have been a lot of Supreme Court proceedings questioning the actions of the body as well. In your opinion, how can there be more institutional integrity? Should there be a change in the law when it comes to the appointment of chief election commissioners and election commissioners? I know that a challenge is already pending. What do you think is the solution?
No, the first thing is that, yes, appointments cannot be by the government alone. That's what the Constitution bench said when they said that
Right.
the selection committee should have the Chief Justice also, Prime Minister, Leader of Opposition and Chief Justice. Unfortunately, the government changed that by bringing a law, removed the Chief Justice and brought in another minister. We have challenged that law on the same ground on which the Constitution bench declared that you can't have the government controlling the appointment process.
Right. What is the status of the challenge currently?
It's coming up again on Tuesday. It will probably be pushed off because of the SIR hearing.
Right.
Because it's the same bench. So one is to ensure that there is a relatively more independent selection committee. And the second is to ensure complete transparency in the processes that they adopt. And that they follow some system. They can't say that we will arbitrarily decide whether somebody is a citizen or not. Even if they want to decide that, they have to have some rules. Okay, on what basis will they decide whether somebody is a citizen or not? Will they decide only, they should normally decide only on the basis of the order of a court or a tribunal or the government of
It has to be a judicial authority.
But suppose they say, no, we will decide. All right, how will you decide? Not arbitrarily. You can't say that if he doesn't produce a passport or a birth certificate, we will say he's not. That way half the people will be excluded. But then they will say, no, we have looked at this person. Suppose the election commission dishonestly wants to exclude the Muslims. For the Hindus, they will say, this is what happened in the NRC process of Assam. So they started looking at documents only. But fortunately, because the Supreme Court was monitoring that process, therefore, documents were not possessed by a lot of poor people. So a lot of poor people, including majority were Hindus, and some Muslims got excluded from the NRC. Then the government of India thought that, all right, we will bring back the Hindus by the CA, that we will say, all right, all these Hindus who have been excluded, they will be treated as refugees who have come from these Muslim countries, and they will be granted citizenship. But the problem there was that you had to declare that you were a citizen of Pakistan or Bangladesh and that you had come in. Most of these people were Indian citizens. They just didn't have those documents to prove. And that's why they were excluded from the NRC. So therefore, if you have to have some system, some rules, some guidelines for seeing how you will decide citizenship. I mean, a court and a tribunal can take into account all the evidence, but the Election Commission is not a court or a tribunal.
And of course, what has been lacking and what has been flagged repeatedly before the Supreme Court by the petitioners is principles of natural justice has been violated. There has been absolutely no an adequate notice given to the aggrieved electors.
Yes, that's right. They were saying that you can appeal against the decision of the electoral officer. There was no time to appeal. The final roll was published. And within days, within 2 or 3 days, the election notification was issued. So who do you appeal to?
And you've also seen, in fact, data analysis done by the Hindu has indicated that the women have been disproportionately affected. There have been more exclusion in the Bihar SIR process. Do you see these concerns being repeated as well for the 12 states and union territories which will undergo the same exercise?
Well, there will be lots of problems if the Election Commission tries to proceed in the manner in which it is trying to proceed. The only way of overcoming those problems would be to have full transparency and to have that Gram Sabha or the social audit. Those are the only ways in which this kind of arbitrary exclusion and arbitrary inclusion and large number of duplicates, etc., will be avoided. That's the only way that it can be avoided.
Right. Thank you so much, Mr. Bhushan. This has been a very enlightening conversation. Thank you so much.
Thank you. Thank you.